Hello everyone, welcome to Pushpaganga Academy for Competitive Examinations. So today we are here to do the analysis of polity and governance for which the questions which came under this topic in the UPSC examinations which was held in the last Sunday. So on the brief, before starting with the questions, so let us analyze. So how many questions had been appear in the previous examinations? So going with the polity section in the year 2014, so we could see there were total number of 11 questions, and in the year 2015 we could see 12 questions had appeared in the examinations. So in the year 2016 there were 6 questions appeared in the UPSC examinations. So there was a drastic decrease. So there was a change from 12 to 6 questions in the year 2016, and in the year 2017 we could see a drastic increase, from 6 to 22. From 6 to 22 there was a rise in the number of questions from polity and governance section. And in the year 2018, so there was a slight decrease. So slight decrease in 13 questions, and in the year 2019 there were 14 questions that had appeared in the examination. Again, in 2020, in 15 questions, there was a last year examination, we had around 15. In 2021, we had got, as anticipated by us, so we had got around 18 questions that was appearing in this examinations. So totally, on an average, there was a high and decrease from 2014 until the last year. On an average, we could go somewhere around 13 and 14 questions you can expect in the examinations. In the same way, so in the same analysis, in the next year also, in the 2022 examination, so the prelims plays a main role. So somewhere on 15 to 18 questions you can definitely expect from this polity and governance sections. So now with this, we'll go with the questions that are appeared in the last Sunday's UPSC prelims examinations. We are focusing on the polity and governance chapter. So on the polity and governance sections. So here is the first question. So we come across under the Constitution, concentration of wealth violates. So here it says that the concentration of wealth violates which of the following? So now there is an options called right to equality, so directive principles of the state policy, right to freedom, and the concept of welfare. So now here we come across four important options. He speaks about the right to equality, and the first and foremost thing is even though we don't know what exactly the answer is, we can just go with this. So here he's focusing on concentration of wealth. Concentration of wealth comes under what? We can go with the elimination of the options. So first thing, right to equality cannot be the answer. So if we eliminate, because concentration of wealth does not deal with equality, we cannot distribute wealth to each and everyone. So right to equality speaks about, Article 14 speaks about the AV principles, so equality before law and everything about that. So this can't be the answer. And C, so right to freedom will not speak about this. Freedom will speak about article from 1922, so it speaks about different types of freedom. So this cannot be the answer. So now we have the close connection with 15 article directive principles of state policy, option B and option D. So among these two, which one is the closest answer? The closest answer, both of them seems to be the right at the front view, but the closest will be, so the concept of welfare. So how the concept of welfare, what does it says about that? Concept of welfare speaks about the concentration of wealth. The wealth has to be distributed among each and everyone. So then it speaks about the welfare state. So here we come across what exactly the welfare state. So now what is the meaning of the welfare state? So now it is the concept of the government in which all this plays a key role, state plays a key role in the protection and promotion of economic and social well-being of its citizens. The welfare state is based on the principles of equality of opportunity and equitable distribution of wealth. It mainly speaks about equality of opportunity and equal distribution of wealth. So earlier when we just speak about that, before the constitution was drafted, so India was not a welfare state before independence. And then after now we also speak about India, whether it is not a welfare state or not. So whether the wealth is being equally distributed, but but after independence we focus on equality, welfare state. Okay, but the welfare state concept comes under the dietary principles of state policy. So even though it comes under the dietary principles of state policy, equitable distribution of wealth means is a welfare state. So this the source of this the welfare state was drawn from NIOS website, nios.az.in. Okay, based on this we can see the answer for this question. What is the position of right to property? Based on this we can go with the question. Under the Indian Constitution, concentration of wealth violates which of the concept? It violates concentration of wealth means concentration, the wealth is been accumulating only one particular person, so it means it is violating the concept of welfare. So the answer for this is D, the concept of welfare. Now we'll go with the next question. What is the position of right to property in India? So right to property, we know that it was amended to the 44th Constitution Amendment Act, and from the fundamental right 331 it was removed from there and it was added on to 300A. From 31 it was changed to 300A. Okay, so through the 44th Constitution Amendment Act it was changed. So now, is it a fundamental right available to citizens only? No, it is not a fundamental right anymore because of through the Constitutional Amendment Act. So is it neither fundamental right nor a legal right? It cannot be any of them. So now we have the closest answer between A and B. So what can be the closest answers in this? So legal right, we know that it is a legal right. Yes, it is a legal right. So available for citizens only, available to anyone, and even a foreigner can purchase a property in India. Okay, so now that's the reason it is not available only for citizens, it is available to anyone. So the legal right, so like for example right to vote and access to government offices, it is available only to Indian citizens. So now whereas the right to property is available to everyone. Explanations for this. Originally the Constitution, as I said earlier, originally the Constitution also included the right to property, Article 31. So however, it was deleted from the list of fundamental rights by the 44th Constitutional Amendment Act. Okay, it was made a legal right under Article 300A in Part 12 of the Constitution. So based on this, the correct answer for this is answer B. So now, we'll move to the next question. So now, what exactly the constitutional status of India on 26 January 1950? So the preamble, the Constitution was adopted. We know that Constitution was adopted on 26th November 1949. But the Constitution came into force on 26 Jan 1950. So it speaks about that. In the preamble, it is mentioned. We know that preamble was the last thing that was taken into the Constitution. And in preamble, it says, it's a straightforward question, it's a simple question, so no trick in this. So we know that India is a sovereign democratic republic. Okay, so the word secular and socialism, socialist was added to the 42nd Constitution Amendment Act later on. Okay, so the correct answer for this is B, sovereign democratic and republic. What does the word sovereign says? We are not under the control of anyone, so we can frame our own rules and policies. What does democratic says? The head of this said we follow the parliamentary form of the government. So we know that democracy has two types of things. So one is direct democracy and the other one is indirect democracy. So the republic says, so the head of the nation is elected, whether it is directly or indirectly. Ours is an indirectly elected. Okay, so the answer for this question is B, sovereign democratic and republic. So again, the preamble was amended by the 42nd Constitution Amendment Act in 1976, in which 3 new words, socialist, secular and integrity, were added. Okay, we'll go to the next question. So constitutional government means, what is this constitutional government? What will we say with that? So constitutional government means, so whether there are given 4 options in this. So the first option goes with a representative government of nation with federal structure, and then B option says a government whose head enjoys a nominal powers, and C option says the government whose head enjoys a real powers, or the government limited by the terms of the Constitution. Okay. So now, what is constitutional? Constitution is the thing which frames the rules and regulations. So we know that we had the constitution when it was adopted. So 395 articles are there. Right now it is more than 450 plus articles. So when the constitution was taken into consideration, we had 22 parts and we had 8 parts, 8 schedules, which was added, which was increased to 12 schedules. Okay. So now, so in this, the constitution is the one which frames the rules and regulations where the government has to be framed. Okay, so we can't say it's a representative government. Constitution government is nothing but it's a representative government of nation with federal structure. Okay, the government whose head enjoys the nominal powers. The government whose head enjoys a nominal powers like ours is the government where the head, so it's like the president enjoys the nominal powers, the government whose head enjoys the real powers, the government, so it's like even the prime minister enjoys the real powers, the president enjoys the nominal powers. So it can, this is be representation of, so this is a representation of the prime minister form of the government or the parliamentary form of the government. So it is not a constitutional government. The constitutional government is nothing but, so it's nothing but a government limited by the terms of the constitution. So now we'll see with explanation about this. So now what it says is the self-explanatory. So answer for this question is D. The constitution government means a government limited by the terms of the constitution. So now we'll go with the next question. So here is the next question. Consider the following statements in respect of Bharat Ratna and Padma awards. So now how does it says with? So the option goes with like this. So there are three statements and then the options are given. The first statement, Bharat Ratna and Padma awards are the titles under Article 18 Clause 1 of the Constitution of India. So then second statement goes like this. Padma awards which were instituted in the year 1954 were suspended only once. Then the number of Bharat Ratna awards is restricted to a maximum of 5 in a particular year. So these were the statements given, and here and the final question was asked, which of the above statements are not correct? We have to choose which is not correct in this. Okay, so option A 1 and 2 only, B 2 and 3 only, C 1 and 3 only, D 1, 2 and 3 only. Okay, so now Bharat Ratna and Padma awards are titles under Article 18 Clause 1 of the Constitution of India. So now we know that they are not the titles under Article 18 Clause 1. Article 18 Clause 1 speaks about abolition of all titles. So this will not be a right answer. Okay, if it's not a right answer, then we are also. So this is the right answer because this cannot be possible. So because he is asking which are not correct. Okay, so this is not correct. Okay, so now this will be deleted. So now Padma awards which were instituted in the year 1954 were suspended only once. So it was not suspended only once. So it was suspended more than once. It was suspended for the twice times. Okay, so this is also not correct. So this is the right answer. So 2 will not be the answer. So 2 will be the answer. So 1 and 2 cannot be the answer for this. So the closest answer will be A and D. In this, which is the right answer will be depending upon the third option. The number of Bharat Ratna awards is restricted to a maximum of 5 in a particular year. It's not 5. The Bharat Ratna awards in a particular year, the maximum is restricted to 3. Okay, it's not for 5. So all the 3 are wrong. Okay, nothing is correct in this. So the answer is, so question was asked which is not correct. 1 is also not correct, 2 is also not correct, 3 is also not correct. So the final option will be D, 1, 2 and 3. Okay, so now let us look for the explanation. So now explanation says the ex-minister of state for the home, Hansraj Gangaram Ahir, said that the national awards such as the Bharat Ratna, Padma Vibhushan, Padma Bhushan and Padma Shri do not amount to the titles within the meaning of Article 18 Clause 1. So now in 1954 these awards were constituted. So Bharat Ratna is the highest constituent award, and then comes with the Padma Bhushan and Padma Bhushan and Padma Shri. So in the name suffixes, and so there cannot be used as prefixes or suffixes to the name of the recipient in any manner whatsoever. So the second option, the Padma Bhushan along with other personal civil honors was briefly suspended twice, as we discussed earlier. It was suspended twice from 1977 to January 1980 and from August 1992 to December 1995. Okay, so it was twice. The number of Bharat Ratna awards is restricted to a maximum of 3 in a particular year. So now based on this, the right answer will be, so the source been mentioned over here. So the right answer for this will be D, 1, 2 and 3. So now here we go with the next question. With the reference to India, the sixth question that was asked in the polity section. So with reference to India, consider the following statements. So now what do you mean by judicial custody? Here he is asking about the judicial custody, and this question was completely based on your NCERT textbook. Okay, it was drawn from the NCERT textbook. So now here it speaks about the judicial custody. So now there is a difference between a judicial custody and a police custody. So whenever a person is been arrested, so he'll be taken to a police custody, and then within 24 hours he has to be present before a magistrate. So now the magistrate, the police can ask for a magistrate whether we need to interrogate him, and then we can take into a police custody, or else the magistrate will not say don't want any for interrogation. Okay, the person can be sent to a judicial custody. If it is a police custody, he will be sent to a police lockup. If it is a judicial custody, it will be sent to a jail, central jail, not for the judicial magistrate house. So judicial custody means, so here is a question based on the judicial custody. Judicial custody means an accused is in the custody of concerned magistrate, and such accused is locked up in police station, not in jail. Okay, so here the question says judicial custody is the custody of magistrate. If it's a custody of magistrate, he will not be taken up to police station. Okay, so not in jail is there. He will not be taken to police station. He will be taken up in a jail. So this answer, this statement is wrong. So first option will be wrong. So here he is asking about which of the statements given above are correct. Okay, this is not correct. This is wrong. Okay, so now, anyway, 1 is wrong. So we'll go with this. So both 1 and 2 will be wrong. So now, during the judicial custody, the police officer, the next option, we go with this. During the judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of court. Okay, it says that. So during the judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. So it's like, for example, it's like as I said earlier, within 24 hours of time he has to be presented before the magistrate, and then after the magistrate gives the permission, he can interrogate. So whether he will be granted to the police custody or he will be granted to a judicial custody. Based on magistrate, he will be taken on to a interrogation. So now during the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. That is nothing but the magistrate. So this answer is right. So we'll go with B only. So the answer for this question is B, 2 only. Here is the explanation for the previous answer. So now what is police custody? We just came to know about this earlier. So police custody means the police has the physical custody of the accused. Okay, it has the physical custody of the accused, while judicial custody means the accused or the culprit, whoever it is, the accused is in the custody of concerned magistrate. Okay, in the former, that is in the police custody, the accused is lodged in the police station. He will be stationed in the police station. So and in the lockup, police station lockup, while in the latter, that is in the judicial custody, he will be in the jail. Okay, so in the judicial custody, he will be in the jail. In the police custody, he will be in the police lockup. Okay, so interrogation by police, as mentioned in the para 4 of Gyan Singh versus State of Delhi Administration in the year 1981, as mentioned in this case. So interrogation by police is permissible. Magistrate can direct the place and manner whether the interrogation has to be in judicial custody or the interrogation has to be in the police custody. Okay, so now here the court can direct, the magistrate can direct mere interrogation by police during such custody by permission of the magistrate, that is nothing but the court. Okay, cannot change the nature of the custody. Okay, so now here this is the explanation for the previous answer. So now the answer for this question will be B, 2 only. Okay, so now we go with the next question. With reference to India, consider the following statements. So the first statement: when a prisoner makes out a sufficient case parole cannot be denied to such prisoner because it becomes a matter of his or her right. Okay, so now state governments, second statement goes like this: state governments have their own prisoners released on parole rules. So now in this, which of the following given above are correct? You need to check about whether it is right or not. So first, the important thing is we need to see whether what exactly it is, whether they are asking which of the following is not correct or correct. Okay, so now A 1 only, options B 2 only, C both 1 and 2, D neither 1 and 2. Okay, so now before answering this question, we must note down what exactly a parole is. Parole is something like a temporary or a permanent free for a person who has been accused, who has been culprit, who has been sentenced in a jail. Okay, so now it based on their records, whether track records, whether he's been performing, he is of good character, or he is showing the positive impact, so whatever it is. So based on that, the parole will be granted. So it's a free going out of the jail for a certain period or permanently. Okay, now let's see what is the answer for this is. When a prisoner makes out a sufficient case, parole cannot be granted or denied to such prisoner because it becomes a matter of his or her right. Usually, parole is not a right of a prisoner. Okay, parole is not a right of a prisoner. So now what happens? It becomes, it says that it becomes a matter of his or her right. It cannot be whether denied or not denial, or giving approval or denial is depend upon the station house officer. So now it does not become a right of a citizen, right of a person. So now this option can be wrong because it says that parole becomes a matter of his right. Okay, it says that it cannot be denied. Parole can be granted or not. It is a discretionary power of the jailer. Again, state governments have their own prisoners released on parole rules. Yes, definitely, it's based on the state governments. The state governments can have their own rule. They can make the rules, regulations on this. So again, it comes under the state as the prisons comes under the state list. So they have their own rules and regulations can be made by the state governments. So now based on this, so answer B will be the right answer. So now let us look about this. So answer B, here explanation is given about the parole. So what does the parole says? Parole is not recognized as a right in India, despite the fact that it has administrative importance. Okay, it is not recognized as a right in India. So now a prisoner's claim to a parole is not absolute and prisoner's authority has considerable discretion. The jailer has the considerable discretion in granting parole to that person. Okay, so now this was about that we are asked, I spoke about this question, the parole. Fine. So now we move to the next question. I hope that you understood with this answer. So now we move to the next question. Here it is a direct question as the sentence itself speaks about that. So now it says that legislation which confers on executive or administrative authority an unguided and uncontrolled discretionary power in the matter of application of law violates which one of the following articles? Okay, unguided and uncontrolled discretionary power. Okay, a person cannot he cannot say authority, administrative authority cannot impose his discretionary power. Okay, so now it says that it is violating which one of the articles? So it's Article 14 of the Constitution, rule of law. Here AVDIC principle will come into apply. He says that absence of arbitrary power. Okay, so now Article 14 is the direct answer, it's the direct question. So 28, 32, 44 cannot be the answer for this. So now we'll see about the next thing. So explanation is given about this. Answer A, rule of law according to AVDIC. It means the absolute supremacy or predominance of regular law as opposed to the influence of arbitrary power, so wide discretionary power. So it means the exclusion of existence of arbitrariness on part of the government. It says that arbitrary power will not be there, it's an absence of that. Okay, so the answer for the previous question is A. So Article 14. So now we'll go with the next question. So which one of the following in Indian polity is an essential feature that indicates it is a federal in character. So now what exactly the federal in character? Federal in character means, so the state government having the separate government having their own separate distinguishing the powers between the distribution of the powers and distinguishing the powers between state government and the central government. We have a state list, union list and concurrent list, and as well as judiciary is independent. Okay, so which of the options it says? The independence of judiciary is safeguarded. Independence of judiciary, we have three organs as I said, so this is the closest answer. Let us look about the third option, another options. The union legislature as elective representative of constituent units, this cannot be the answer. The union cabinet can have elected representatives from regional parties, again this cannot be the answer. So the fundamental rights are enforceable by court of law. Yes, fundamental rights are enforceable by court of law, but again, this does not make a federal in character. So the federal in character answer will be A. The independence of judiciary is safeguarded. This is the right answer for 9th question. So here is the explanation given for this. So now it says that the Indian Constitution establishes an independent judiciary headed by Supreme Court for two purposes. One is to protect the supremacy of the Constitution by exercising the power of judicial review, and to settle disputes between the center and states or between the two states. Okay, so the independence of judiciary also imparts the federal in character of a state. So now the next question, and is the last question of the day of the topic. Which one of the following best denies the state? As the name itself suggests, what exactly the state indicates. So now what exactly the state says according to Article 12 of the Constitution. So now 12 states about it clearly mentions about what exactly the term state denotes: the union and the state governments, the parliament and the state legislatures, and all local or other authorities within the territory of India are under the control of Indian government. So it speaks about that state. So now in this we'll speak about that, what exactly it is. The community of persons permanently occupying a definite territory independent of external control. Okay, in a state, so someone is not controlling us, we are not being occupied by someone else, we are not being exercising control by someone else, we are independent without permanently occupying definite, independent of external control, and possessing an organized government, that is a systematic government, republic, sovereign and democratic. A politically organized people of a definite territory possessing an authority to govern them. Okay, it's about someone else governing us. So maintaining a law and order to protect their natural rights and safeguard their means of sustenance. So this is not the answer. A number of persons who have been living in a definite territory for a very long time with their own culture, tradition and government. Again, this cannot be the answer. So society permanently living in a definite territory with a central authority and executive responsible to a central authority and independent judiciary. So this cannot describe a state. So a state is nothing but a community of persons permanently occupying a definite territory independent of external control and possessing an organized government. Okay, it has an organized government, so a proper hierarchy is there in this. So now it says about that, we already came across this. So these are the 10 questions that we come across the polity and governance segment in the UPSC exams that was held on the October 10th, so the last Sunday. The remaining topics will be coming across in the next session. So I hope you enjoy this session. Thank you, have a nice day, and we'll meet you in the next session. Thank you.